The 14th and 15th Amendments came about in the Reconstruction era after the Civil War as a means to guarantee that states would uphold the rights of African Americans as U.S. citizens, namely the right to have equal protection of the laws and the right to vote regardless of race. But in the following decades, many Southern states used various tactics to skirt these amendments and deprive African Americans of their rights. One such tactic was called the white primary, in which states allowed private political parties to impose race restrictions on party membership and primary election voting. In Smith v. Allwright, the Supreme Court decided whether a white primary in Texas violated the Constitution. Texas law required its political parties to hold primary elections in order to select candidates who could run in the general election for U.S. senators and congressmen. The law only allowed party members to vote in these primary elections, but empowered the political parties to set the criteria for party membership. Based on this statutory authority, the Texas Democratic Party adopted a resolution in 1932 to exclude all non-white people from party membership and primary voting. In 1940, Lonnie Smith, an African-American registered voter, attempted to vote in the Texas Democratic primary election for U.S. senators and congressmen. But the election official, S.S. Allwright, refused to give Smith a ballot because of his race. Smith then sued in federal district court, seeking the right to vote in the primary. He argued that the Democratic Party discriminated against him and deprived him of the right to vote in violation of the 14th and 15th Amendments. The district court denied Smith any relief, and the Fifth Circuit affirmed. Smith then appealed to the United States Supreme Court.